I'm going to briefly first cover what is privacy by design. I don't want to go into too much detail. There's a lot of information out there, but it's useful to explain what it is. I found this useful quote on one of the reports prepared for the Information Commissioner's Office. This is a quote by a chap called Toby Stevens. The Privacy by Design programme will encourage public authorities and private organisations to ensure that the information systems that hold personal information and accompanying procedures are developed, privacy concerns are identified and addressed from first principles. In short, this means designing in privacy and data protection compliance rather than ignoring it or bolting it on as an independent afterthought. There's lots of various terms for privacy by design. It's linked to data protection by design and privacy by default. There's often a misconception with data protection. If you mention data protection to the member of the public or even my managers, they automatically equate that with data security. It's easy enough. All the media headlines about data protection is X body has lost 5,000 records. Privacy by design is considerably wider than that. My personal view is, as I've said there, it seeks to embed data protection into the DNA of the system of processes with a view to actually implementing that into the actual DNA of the organisation, trying to explain to the organisation how and why they're processing personal data and what they're planning to do with it. That is often harder than just merely stating to them, you must keep this data secure. In doing that, you look at your privacy policy, any fair processing notices you've attached to your collection of data, and you're also looking at the basis of how and why you're collecting it. Privacy by design. Key elements. If you read the ICO's guidance documents on privacy by design, it focuses on two areas, data minimization and privacy enhancing technologies. However, privacy by design is considerably wider than that, and it starts and ends with privacy impact assessments. This is a bit where I ask you, how many of you have actually undertaken a privacy impact assessment? I'd say that's about 50%. How many of you have done more than 10 privacy impact assessments? Slightly less. More than 20? That's 3. So far I've done about 50. Initially, you'll undertake a privacy impact assessment to determine whether or not you even need to consider privacy by design. For those of you who haven't undertaken a privacy impact assessment is effectively a risk assessment. You're undertaking analysis of the nature of the information you're holding, what's the potential impact or prejudice to the privacy of the individuals you're collecting that data, and then what steps can you do to mitigate it. If you look at Article 23 of the current data protection directive, I always keep getting them confused for some reason. It states that the controller shall implement appropriate measures for ensuring by default personal data are not accessible for the specific purposes of the processing or processed. This applies to the amount of data collected, the period of their storage and their accessibility. So by its very nature, it's considerably wider than a data security audit. I'm going to go over in brief some of these points. Okay, privacy impact assessments. These need to have a buy-in from both senior managers and staff handling the data. Senior managers, because they're going to be paying for it, and if they're not prepared to pay for it, you're going to have a hard job trying to persuade anybody else to do anything. And staff handling the data, because they need to actually have an input into what you're proposing to do. I've been fortunate insofar as I've been able to get corporate buy-in at the council for privacy by design and privacy impact assessments. I say that there was out of the 6 directorates at the time, there was 5 that bought into it and 1 that didn't. The one that didn't got sanctioned by a statutory regulator, and now I'm having to do the whole work again in relation to them. We still undertook a privacy impact assessment in relation to that one organisation, and that must have been the longest 2.5 hours I've ever spent in a meeting. Every single thing we discussed with them, they came back with, we have concerns. We were sat there for 2.5 hours. We raised one issue. Could we share data of the social worker on this file with the user if they phone up or give the contact details? No, we have concerns. When you asked them what the concerns were, they couldn't answer. They just said, we have concerns. So by the end of it, me and the consultants who were working with me on this project basically were just, I don't know, we just given up the will to live. We thought it was a small blessing when they decided they weren't going to take any further part in the project. Needless to say, they promptly got, as I said, severely sanctioned for lack of effective data sharing in the organisation. And bearing in mind it covers children's services and you only have to look at any safeguarding report, the first thing that they will criticise any public body for not doing in relation to a safeguarding issue is sharing data effectively. As I said, we're now in the process of having to rectify that by doing a separate data sharing project internally in that organisation. And we are pushing forward with privacy by design in that. However, that is a lot more sensitive, seeing as you're dealing with children's data, than the various other parts of the council.